J-E-L-L. All.
All right, Jello again. We're getting right to it. So, what page? Let's go. We're going to go just to recap. We are in California County Court, Superior Court, County of San Diego. This is Redden and Riddell. R&R does sound pretty cool. Superior Court. Here are the claims. So there's 12 of them. And then this is Jane Doe, who's a pupil at the Poway Unified School District and one of the leading pitchers on the softball team. Apparently, there are some number of them. And her parents. I think that John Doe is her father. Then there's Poway Unified School District. Then there's the high school. Totally bizarre to me that the high school itself is its own entity. It says it straight up, a California public entity. Marion Phelps, an individual. James Dayoff, he's an employee at the district involved in this writing of this sort of forced statement of guilt. I had one of those once. I had this one where the city of Milwaukee, in order to contest a parking ticket, you had to sign a document saying that you were responsible for the parking ticket. That is about 10 stories for 20 other days. There's a lot. This is why going through these are useful. Dave LeMaster, he must be another employee there. There's reference to him in this letter, but I don't see him. He's probably an assistant principal. Mike Giammi, an assistant principal whose daughter is also a pitcher. Michelle O'Connor Ratcliffe, a trustee, school board member. Darshana Patel, school board member. Heather Plotsky, and so forth, all school board members, and Doe's 1 through 100 inclusive. Let's just check out who this is. Why are parties important? Because it's important which counts are on which parties. So now we'll go up to parties, all parties, Jane Doe. We'll just look at some of these one here. Marion Phelps is and was the superintendent at PUSD, acting as an employee agent at PUSD and acting or purporting to act in her official capacity as such. She is vested with the authority to discipline students within the school district at her discretion and to enforce the policies of the district. I would say that is a very true statement. Dave LeMaster is and was executive director 2. Wow. I mean, I've heard of directors and executive directors, but an executive director 2. I'm going to say this man's title out loud. Executive Director 2, Secondary of Learning Support Services. All right. These are statements that saying that they're acting in their, besides anything else, they're acting in their official capacity. Here's the acting assistant principal. Brian Schultz is another principal of very interesting. I'm trying to think of sentences in which these guys are implicated before, but we'll go back for the counts. That's what that's for. And then I just want to point out, here are the school board members who has ultimate, okay, in my opinion, and I don't know that rules there. I know it more in my district or circuit. What I've seen so far in the complaint is not enough to get the individual board members on the hook, merely because as a group, the only person that I've seen is this Patel person who made false statements afterwards, or allegedly false statements. I think that was right. It's the first one that starts with D. Yeah, Darshana Patel. Okay. So I just wanted to get that clear, and now we're going to go down to counts. So let's see if I can do this. Bam. Causes of action, counts, same. Those are interchangeable. First cause of action. Violation of First Amendments through the 14th Amendment. And that's your 1983 claim. As we read, we've gone several times through the jury instructions here, but let's just remember, acted under color of law, that the act or failure to act of the defendant deprived the plaintiff of particular rights under the laws of the United States or the United States Constitution. The defendant's conduct was an actual cause of the claimed injury. Okay? I think that third part is kind of important to them not just acting as a group as well, but we'll be okay. And so this is against all the defendants have violated this person's First Amendment rights, okay? Plaintiff realleges and hereby incorporates each of the preceding paragraphs. Deprived and continue to deprive the plaintiff of the right secured to her by the United States Constitution. I guess specifically the First Amendment, we can infer from that there. This is just notice pleading. It doesn't have to be very specific at all, but it needs to be clear that this is... what I mean by that is it can't just simply name the elements. For example, there's got to be something. There's got to be a specific plausibility about the whole thing. Okay. By investigating, harassing, intimidating, threatening, bullying, retaliating, disciplining, and or revoking extracurricular privileges, including in plaintiff's ability to be on the Del Norte High School softball team, for an alleged incident of exercising her free speech or exercising her right not to speak, defendants have violated and are continuing to violate plaintiff's right to free speech and expression, and in particular her right against compelled speech as guaranteed by the First Amendment and the 14th Amendment to the U.S. Constitution. That's a lot of information, but I think it's essentially correct. Then I guess part of what I would say is some people fall into the trap, and you may want to do this, you may not, but it's sufficient as far as I'm concerned to say investigating, and some people might be tempted to say investigating on June 12th, this investigation. That sometimes can cause pitfalls by being too precise. Sometimes less is more. Sometimes it's not. How's that for help? By requiring plaintiff to sign and to agree to the terms stated in the OMCC as a condition for her to engage in extracurricular activities or privileges, including plaintiff's ability to be on the Del Norte High School softball team, defendants have violated and continue to violate plaintiff's right to free speech and expression, in particular her right against compelled speech as guaranteed by the First Amendment and 14th Amendment to the United States Constitution. Defendant's actions also constitute a prior restraint on plaintiff's right to free speech. Totally agree with that. And I agree that 103 is absolutely, that's great as a second pair, as that pair. I would say this. I'm wondering if 102 shouldn't be branched out into sort of separate complaints, separate just paragraphs to be clear on because I guess this 102 thing is really the sort of administrative investigation as instigated by the Phelps. But it seems, I guess, what then are we to do with the fact that the plaintiff was already prevented from extracurricular activities, albeit not the softball team, in the fall of 2023, sort of prior to the clapping incident. And I'm just wondering, so this is putting everything onto the clapping incident. I guess that's what I'm saying. I kind of felt like there was more outside of that. No, this is why complaints are tough. Because this document's going to be screwed. You've got only so much time to do it. You got a lot of incentive to get it out there, and it's going to be scrutinized by everybody for, a while here. By taking actions designated to restrict, compel, restrain, and otherwise quash free speech and freedom of expression, defendants have violated and continue to violate plaintiffs' free speech rights and right against compelled speech. Okay. In depriving plaintiff of these rights, defendant acted under color of law. State law. This deprivation under color law is actionable and may be redressed by 42 U.S.C. 1983. Some people feel you do need that statements of law in there. Some people think the heading is good enough. It could go either way. This thing right here it's very sorry. This statement here against who are the parties. If I can just highlight this here. You are not playing fair with me today. Highlight is blue. Fine. It's going to be assumed that you're filing against all defendants unless you make a statement otherwise. Right. So if you just put defendants here, it's going to be assumed that you mean all defendants. I just want to say, I'm concerned, and maybe this isn't an issue here, it doesn't matter, but I would want to have seen statements about individual board members violating her free speech rights. Second cause of action, violation of Article 1, Section 2A of California State Constitution, 42 U.S.C. 1983 against all defendants. California Constitution, Article 1, Section 2A states that every person may freely speak, write, and publish about her sentiments on all subjects, being responsible for the abuse of the right. A law may not restrain or abridge liberty or speech of press. Defendants are deprived and are continue to deprive plaintiff of her rights secured by California Constitution. Defendant's conduct violates plaintiff's right to freedom of speech under Article 1, Section 2 of the California Constitution. I'm concerned about that because if we go to our if we go to our 1983 claim, which I believe that's what this says, 1983, we see that the act has to be a particular right under the laws of the United States or the United States Constitution. And I don't believe that the California Constitution is a law of the United States or the United States Constitution, but I may be wrong. Okay, third cause of action. Violation of Section 48950 of California Education Code against all defendants. Plaintiff realleges and hereby incorporates each of the preceding paragraphs. I guarantee you that in Wisconsin, that violating, if some administrator violates the Wisconsin statutes regarding what your child is, there's no cause of action here if they violate the rules of the public instruction rules. Absolutely none. If they fail to file a bullying, that's not entirely true. That's not entirely true. They're toothless, and you certainly cannot go to court and sue them for damages. Let me rephrase that. You can go and say that they didn't do the process right, and then they can fix it. Okay, among other things. In relevant part, a school district operating one or more high schools shall not make or enforce a rule subjecting a high school student to disciplinary actions solely on the basis of conduct that is speech or other communication that, when engaged in outside the campus, is protected from governmental restriction by First Amendment to the United States Constitution or Section 2 of Article 1 of the California Constitution. Defendants deprived and continue to deprive plaintiff of their rights secured in her by the Education Code. Okay, just not clear that that's a right of action. Discipline policies of both the PUSD and Del Norte High School permit defendants to investigate, harass, intimidate, or revoke extra as a punitive disciplinary action, including plaintiff's ability to be on the Del Norte softball team for an alleged incident of exercising her free speech or exercising her right not to speak. Oh, okay. The discipline policies of both the high school and the district permit the defendants to require her to do this. Because the rules are illegal, they violated the code. Okay. So this is not right. It's not really against all defendants. It's really against PUSD and the high school. Again, I'm very suspicious that the high school is a independent entity that can be sued, but we'll find out. Hereby incorporates each of the preceding paragraphs. Students shall have the right to exercise freedom of speech of the press. Speech can be prohibited only if it is obscene, libelous, slanderous, or incites the students to create a clear and present danger of the commission of unlawful acts on school premises or the violation of lawful student regulations or the substantial disruption of the orderly operation of the school. We've kind of talked about that before, right? They have sort of it's freedom of speech, but it's restricted because it's a quasi-military environment in which, they can tell everybody to shut up. Okay. The alleged conduct, number one complaint my kids have about Dana schools, I remember my son had, is that they don't tell everybody to shut up. I've always thought that was really funny. As probably being one of the kids who would like that the most. The alleged conduct of not clapping when JP was announced an award at the softball banquet is a protected expression of one's views, opinions, and feelings. This is a fine place to put conclusions of law, by the way. Clapping or not clapping did not cause a disturbance and is not vulgar or obscene. Plaintiff and anyone's display of clapping or not clapping is fully protected by this provision. Now, you don't put the damages that you want in each paragraph here, but you do sort of put a prayer for relief at the end, and we'll see how that lines up. But that's my main concern now is, are these California education codes enforceable privately in this way? Prior restraint, the OMC requires compelled speech by plaintiff to staff every 2 weeks. I don't get that every 2 weeks part, but okay. Did she have to re-sign the document? If she did, I didn't get that. We're sort of reading this silently together, partially because I've been at this for several hours, but also because I don't get it. Violation of the 14th Amendment against all defendants. Has the right to substantive due process, which includes a property interest in receiving a public education. Believe it. Defendants' conduct effectively deprive plaintiff of her right to receive public education under the 14th Amendment by investigating, harassing, intimidating, threatening, bullying, retaliating, disciplining, or revoking extracurricular privileges, including plaintiff's ability to be on the Del Norte High School softball team. For an alleged incident of exercising her free speech, defendants have violated plaintiff's right to receive a public education as guaranteed by the 14th Amendment to the United States Constitution, period, the end. By requiring her to sign the OMCC, they violated her rights. By taking actions designed to harass, intimidate, threaten, bullying, retaliate, discipline, and or revoke extracurricular privileges, are continuing to violate the public's right to a free public education. Get that. I don't like that. How can I put that in another way? And I'm sorry to just sit here and stare at these things. Sorry, it took me a second to figure that out. Let's just read this here. important part is all persons, Fourth Amendment to the United States Constitution. No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any. Right, and that's, I can see if you think that there's a right to travel, that may be where that comes into conflict. That may be. I think it's whether it's a privilege or immunity, I think, is the key question here. I'm trying to remember where else I've seen that. I don't want to get off on that tangent here, but man, is it tempting. Nor shall any life, liberty, or property, okay, those are key things, without due process of law. That's my favorite section right there. Nor deny to any persons within its jurisdiction the equal protection of the law. Okay, that, if you don't recall, is another one of my favorites. That equal protection, especially class of one. Let's just talk about it like this. That case is fairly simple. Oh my God, we're already 21 minutes here. Start in the 7th District. Where the heck? Indiana, something like that. So-and-so gets, makes the local mayor upset, goes into the village hall, speaks in front of everybody, and says the mayor's no good, Nick, something along those lines. Soon after, she tries to get a sewer line, and they're like, cool, that'll be $26,000, please. She's like, well, this is in the 80s. She's like, well, how much is it for everybody else? Everybody else, $250. And she basically successfully sued that she was in this class of persons. They did that for no governmental reason, and that she was in the class of persons who were being the only reason that they did that to was the only person they did that to her was her, and the only reason they did that to her was because she exercised a right, and they didn't. They were going after her for that purpose. I hope that was not too confusing. Okay. Due process of law is normally I'm dealing with that in terms of you've got as a government employee, you've got due process rights, and they're trying to deprive you of your property, your job interests without due process. But also that comes up fairly frequently when we're just trying to have a hearing in front of the Equal Rights Division. But hey, that's how that goes. So, the 14th Amendment is an amazing thing. Okay. Who even knew about this? The rest of this stuff? I didn't. All right. So that's the 14th Amendment. So what I'm saying is there are 14th Amendment equal protection claims, there are 14th Amendment due process claims. I think that both of these things are getting shoved in together. I would like to see these be violation of 14th Amendment, parentheses, equal protection, violation of due process. I think she's totally getting no due process in terms of they convicted her before she had a hearing ultimately. She was being forced to, I think that can't be understated enough that she's being forced to confess because when they failed to get the goods on her. And they won't let her do something that she's otherwise entitled to, life, liberty, or property, because she refused to sign a document saying that she was already guilty. You can see how that would be problematic in America. Also, it seems like the government, meaning Phelps, went after her because, and possibly others, and it can be class of 1 or class of 5, because they didn't clap enough. And that could be a equal protection claim from what I saw, 100%. And this is focused on right to a public education. I can see how that's sort of a due process claim, but ish. It, I'm not being that clear on this, and I'll say you have a property interest. This is a due process claim. I would say that there should also be an equal protection claim, and maybe we saw that here. Here's the equal California one. I told you again, I don't think that 1983 claims are, whoa. Just, all right. I really want to, so here we're getting into law here. I do not suggest putting law in this area here. You can sometimes need to educate a judge about what the law is, and that's a fine place to do it, but it's not necessary, and especially here, I wouldn't put it in there. I'm very confused as why this is not a U.S. constitutional claim. I'm not clear on that. Maybe that's coming otherwise. Again, here, I don't believe that you can enforce the California Constitution in the federal courts by the 14th Amendment. But again, we can go back to that, but I could be wrong, but I doubt it. Okay. Let's just quote it, though. A general diffusion of knowledge and intelligence being essential to the preservation of rights and liberties of the people, the legislature shall encourage by all suitable means the promotion of intellectual, scientific, moral, and agricultural improvement. Oh, this is their equal opportunity to engage in extracurricular activities. Intentional inflictions of emotional distress. They made that in, this is a state law claim, intentional infliction of emotional distress. I'm sure it's got similar elements to what we have here. I can think of like several reasons why that wouldn't fly here, but I guess, except not against education board of education members. You see that part? Okay. That's not how I would phrase that, but I can tell they're getting tired too. Oh, a fiduciary duty to their students, engage in outrageous and despicable conduct that was intentionally for the purpose of causing her to severe breached her fiduciary duty and owed as well. This is another state law claim, same thing there. Here's what I would say about that. And I think they're overpleading for a lot of reasons there, but let's just say, for example, and I use this example fairly often, you have a sex discrimination claim and an age discrimination claim. But the sex discrimination claim is 10% likely to go. The age discrimination complaint is like 90% slam dunk. You may just not want to even put in the sex discrimination thing. You may want to put it as insurance. You may not. There's reasons to streamline things. These are strategy decisions. People make and don't make decisions all the time in those reasons. But here, my concern is I don't know what extra damages you would get if they found an intentional infliction of emotional distress. Besides, again, me being worried about the state not really allowing you to sue the school district for that. This again may be one of the reasons why as we went in another video, they seem to be more focused on consumer. They don't seem to be focused on school stuff, which is fair enough. and there's no reason they would. But I'm just generally skeptical of these kind of state law claims against the government because there's so many barriers between you and them. And a lot of the reason why people use these federal claims is because the federal government cuts basically through all that stuff, especially the notice and other sort of requirements along that lines. And since this is a government actor anyway, normally I think I'm focused on the constitutional ones. I definitely put defamation, we'll plead defamation, we'll plead all sorts of things like that too. I won't leave them out necessarily, but again, there's immunities. There's a lot of immunities. So, and every immunity causes more paperwork, and all the paperwork costs more, and all your costs are deducted from your winnings, to put it another way. Any employee who observes or has knowledge, we'll just keep going here because I want inappropriate conduct. I have no doubt that it's totally inappropriate to do with, Exhibit 9, professional standards. I'm very skeptical that there would be a private act of by engaging here. Sorry, this should say it all, and this is something this is a lesson to everybody to be wary of. It's my guess, and I don't know, that there is absolutely no way for a private enforcement, meaning you, to go and sue in court because the school district is violating its own policies. I don't want to put that categorically across the board, but in this sense here, just because somebody isn't violating, to have normally you'd probably do a failure to supervise claim. Discipline measures and standards. You can see why these are totally discretionary, following policy. Policies are guidelines. There's no contractual basis or any other basis here for somebody can be fired for violating a policy, but they can also not be fired for violating a policy. There's no they don't mean anything, and they're not legally binding. Negligence, there's failure to train and supervise. I don't like that one either. All right. This is, I think, where, and I did give a little short shift to the last, and I'm sorry, but, I got some things to do. Request for relief. This is important because this is where you lay out, and you can, I don't think it has to be exhaustive, but I think you got to get the good stuff in here. Violation of First Amendment, declaration that they violated the First Amendment. They violated the California Constitution. They violated Education Code. That they violated the 14th Amendment. That they you may be able to get a declaration of that's called a declaratory judgment that under the California law that they violated the Education Code and no damages. That might not surprise me. That's why we waited until here to check this out. And again, I'm very suspicious that a court will say that so-and-so violated their policies as a straight-out matter. A declaratory judgment, so take no action designed or resulting in infringing on her state constitutional rights. Fair enough. Exercise her free rights, including playing on basically an order saying she can play on the softball team. Fair enough. Restraining order. They don't trust them at all by now. I think they went through mutual cooperation or whatever that they went through that. I mean, yeah, okay. A temporary restraining order, political and permanent injunction, and writ of mandate restraining and preventing defendants and their officers, agents, and any other persons acting with them from violating any PUSD policies as they relate to plaintiffs, other students in the Del Norte SAW. I don't know that he's got the ability to ask for that on behalf of anybody else. And I'm just pointing out that I think that has the same value as them making her sign something that she would follow the rules. It's kind of silly. Just temporary restraining, but you're just basically thinking about everything, and you're also here. This is a statement to the public, so it's okay. Temporary restraining order, writ of mandate, preventing Phelps from messing around. Or being involved in the wish list, but that makes sense. A temporary restraining order preventing Phelps from doing the following things. Coming with 10 yards of her contact. Investigating, harassing, intimidating, never happened. Bullying, retaliating, threatening, or disturb the peace. Declaration against Phelps in compliance with applicable law relating to employee misconduct and allegations in this complaint. A declaration that the following policies threatened to be taken by defendants to and against plaintiff are in violation of the law and or this policy. And a preliminary and permanent injunction of just think about why no court is going to issue an injunction preventing a superintendent for suspending a child for any reason. Just think about that. All right, here we go. Compensatory damages, according to proof. I like that formulation. Incidental and consequential damages, according to proof. For pain and suffering damages, according to proof. For punitive damages against all defendants other than governmental defendants, PUSD, and Del Norte High School, because you can't get punitive damages out of them. But you can get them out of individuals, and then those districts will reimburse them. Prejudgment interest at a legal rate, attorney's fees, cost of suit, and such other and further relief as the court. Well, they got everybody sign on it. Good for them. May deem just and proper. Dated November 27th, 2023. All right. Well, there you have it, ladies and gentlemen. That is the complaint by my learned colleagues there. And as I said, more power to them. I think we looked at it all. And the main lesson here is remember when you're a professional and remember when you're a parent. And usually those two things don't mix. And boy, this superintendent should have thought about these actions, but the thing here that I always find the most interesting is this: why did it take 9 months for the board to act? On the other hand, we need to compliment this board for acting because most would have not. All right. Last but not least, let's not forget the role of the attorney in this situation, who seems to be acting on behalf of the superintendent and her daughter and not necessarily the district. All right. Do we have some outro music? I think we do.